One disposition that's often offered and considered a good deal is a conditional discharge. Okay, conditional discharge is at the very low end of the spectrum of guilty pleas one can enter. So with a conditional discharge, you're entering a guilty plea. You're found guilty, but no conviction is entered. So you don't end up with a criminal record. But what you must remember is that it will be on a criminal record check for 3 years. So if you're thinking employment-wise, crossing the border, etc., in the database, if you look it up, you'll say conditional discharge for assault example, the period of probation that attached to the conditional discharge, and that will last for a period of 3 years. After 3 years, it should no longer be on your record. Sometimes you have to actively apply, but in most instances, it fades away. But what people often don't know or don't understand is that just because it's not a criminal record doesn't mean it will cease to appear the moment you walk out of that courtroom. It has a 3-year consequence, okay? Absolute discharges, which are a step down and as low as you can get with a finding of guilt, it lasts for 1 year and have no probation conditions attached to them. But again, 1 year, it's going to show up on your record. So if you are thinking employment-wise, these are significant considerations. However, for people who are worried about immigration, a conditional discharge and an absolute discharge are not going to impact your permanent resident status. So you can enter into a conditional discharge or a absolute discharge without affecting your permanent resident status. And that is something you want to be always aware of. And what I recommend is that before, if you are not a Canadian citizen, you ever enter into any sort of guilty plea, is that you have a conversation with an immigration lawyer. So I'm a criminal lawyer, but I often will send my clients to an immigration lawyer to ensure that the resolution that is being agreed to is not one that's going to negatively impact someone's immigration status. So for that reason, always, if you have immigration issues, you should speak to an immigration lawyer. Criminal lawyers may know generally what the issues are, but it's always best to speak to the experts. So that's what I have to say about a conditional discharge and an absolute discharge, which are often really sold as your best possible resolutions if a peace bond or the alternative measures program aren't available. But you also have to take into account the fact that you are on your record, and also in terms of immigration consequences, generally you need to speak to an immigration lawyer. I can tell you, in my experience, they don't affect permanent residency status, but certainly speak to an immigration lawyer before you make a final decision about how you're going to resolve any matter before you do so. So conditional discharges, absolute discharges, that's my perspective. And I'm happy to talk to anyone who has questions about those type of resolutions or any other questions that somebody may have about criminal law. And if you have questions about immigration law or any other area of law, I'm happy to connect you with the network of professionals I work with. My name is Dan Murphy. I'm a criminal defense lawyer based out of Edmonton, and I look forward to speaking to you. Shoot me an email, give me a call, and we can speak further. Thank you so much, and take care.